The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I am William Meade. With me today are Justices Massing and Singh. If we run into any technical problems, we'll do our best to reestablish contact, and no one will be deducted any time. If you see us glancing to the side or something, we're probably looking at our notes that may be on a different screen. With that, this case is impounded, as you know. It's 21P854 John Doe number 302343 versus the Sex Offender Registry Board. Mr. Stiles.
Yes, good morning, Justices, and may it please the Court. My name is Attorney Ethan Stiles, and I appear on behalf of the petitioner in this Sex Offender Registry appeal today. And he comes to you today because the board took 6 years from 2013 to 2019 to reclassify him, due in the larger part to its own inexcusable delay. The petitioner's classification level has been in a state of flux for most of the last decade. It started with a 2 in 2011, and then was raised to a 3 for the initial reclass in 2013, and then knocked back down after Doe 380316 was decided due to the implications of that decision, but was not again dealt with until 2019, when it was again raised to a 3. And the only thing we have that might suggest any kind of delay was some kind of procedural error. We do not know what the procedural error was, but I would suggest that there is no procedural error within that time frame that could justify a delay of 3 years between.
I'm sorry, I want to cut to the quick here. You're raising this for the first time on appeal, right?
That is correct.
So if we can hear it at all, I'm not sure if this type of issue is completely waived, or if we review for a substantial risk of miscarriage of justice. But let's assume in your client's favor that we are looking for a substantial risk of a miscarriage of justice. What is your argument that this delay hurt your client as opposed to helped him?
Well, there are a couple of things that happened. First of all, that in 2019, the board is relying on stale information. It's relying on material that occurred, the information that was originally known to it in 2013. And our cases do cite for the idea that the board needs to act promptly on reclassification matters, especially when there is an issue of that, when it actually does act, that the information became stale. And I think a case that actually reflects that best is the case of Doe 7083, which is cited in my brief, and which dealt with the issue of classification hearings happening while a person was incarcerated with no immediate chance of release as a practical matter. So I think you have some inkling of prejudice here. Now, in the decision itself, the hearing examiner in 2019, in addition to treating the 2013 allegations as if they were yesterday, also looks back to the 1985 allegations and gives them much more weight than they have been in the past. You can compare the 2011 and the 2019 decisions, and you start to see things that are given greater emphasis due to those 1985 allegations, which do not result in conviction, as opposed to the 2011 that did not move the bar beyond a 2. But there is another strain of cases that also talk about that even if the prejudice may not be of the greatest impact on the petitioner, there is still ways that the courts can encourage the Commonwealth or its various entities to proceed in a more prompt fashion by granting limited relief to petitioners. And there are two cases.
Can we revisit the procedural issue? I wanted to make sure you answered Judge Massing's question, but you don't cite any case that says the substantial risk standard applies to waived issues. And you also don't cite any cases where this court addressed something for the first time on appeal in a SORB case.
I
So
don't.
what's your authority? What's your authority for us applying substantial risk? The only case I could find was an unpublished decision, and we said that we cannot do this.
Obviously, an unpublished decision makes, but I think, you know, the case of Poe was cited as an issue of substantial risk in the context of ineffective assistance of counsel. Now,
well, I mean, the other thing, as you know, doing quite a bit of criminal work, that we frown on raising ineffective assistance claim for the first time on appeal.
Yes, I'm aware of that. But
there doesn't seem to be a record here at all from which we could even begin to analyze whether counsel was ineffective.
Well, I would suggest, first of all, that any attorney looking at the procedural background of this case, as they are obligated to do, that the 6 years issue would probably raise a red flag as a potential issue to be raised. It wasn't here. So,
well, I mean, but we don't know what counsel was thinking because we can't find facts. What we do know, and you admit, is that the petitioner benefited from some of this delay. In fact, the SJC changed the quantum of proof necessary to establish the classification.
Yes, that is true, that there may have been some benefit to the classification of approval. However, if there was promptitude in the application of that, then we wouldn't be here today. We'd be having a different discussion today. But to get back to your point, I would suggest that any procedural delay of 3 years is too long, absent circumstances beyond the board's control. Now,
so reasonable.
I'm sorry?
What is a reasonable time frame?
I would suggest, Justice Singh, that reasonableness, once you get beyond a year of inactivity, then I think you start looking at unreasonableness. I know that there was one of the cases, I'm not sure if it's a published case or not, that said, as Doe 3177, that said 8 months to correct the procedural error, which probably occurred here, was appropriate. But here we have 19 months of delay, at the very least, if not 38. I think you can make the argument either way. But still, this is a substantially longer period of time. And I know that some of that was covered by the need to process a lot of cases after Doe 380, 316. So now the board sent a notice to the petitioner in July.
Mr. Stiles, those are the sort of things that would need to be ferreted out before the hearing examiner as to what the backlog was, what the procedures were, how long it would take, how many cases they had. Those are things that we don't have any of that.
Well, we do know that the board did say that their backlog had been essentially eliminated in 2017. I think that was quoted in one of the cases I cited in my brief. I think it's in the brief, I believe. That so essentially, you know, and they even sent the notice in July of 2017 that seemed to say that your case is going to be reclassified in the near future, but that didn't happen at that time. And I believe that now regarding this delay, what we do know about it is, first of all, that the petitioner bore no responsibility for any delay. Otherwise, we'd have heard about it. That in assuming that this delay was due to the failure of the board.
Well, I mean, would we have heard of it if he didn't raise it? I mean, why would there be any need to respond to it if it's not raised?
I'm sorry, Justice Massey, I didn't understand your question.
You said if the delay had been attributed to the petitioner, we would have heard of it, but that would only be if he raised the issue. There's no need to respond to it if it's not before the board or even before the Superior Court.
Well, that's correct. But anyway, we could have heard about it at a later time due to motions to expand the record if I could anticipate that such motion could be filed.
It seems like the petitioner himself has delayed in raising this issue, as Justice Massey was. He didn't raise it in Superior Court, and he didn't raise it before the hearing officer.
Yes, that is correct. Although I don't think that should reflect on him personally. That may reflect more on his attorneys at the time. But it was not raised, even though the issue was quite apparent just due to the timeline alone.
I mean, but how do we know it's apparent other than your representation?
Well, I would suggest that the attorneys that my predecessors would have been aware of how long this case, what happened in this case, why it started in 2013, and why they're being appointed after Doe 380-3116. Any practitioner would know of the import of that.
Well, the standard is whether it's reasonable or not. There's no finite amount of time the board has to process a reclassification, right?
Well, the board is subject to due process constraints like the rest of us. And if they do take an unreasonable period of time and subject the petitioner and the public to uncertainty unnecessarily, then this court does have the authority to come to some kind of action.
Counsel, isn't the issue here that the reasonableness of the delay is evaluated by the reason for the delay, and we don't know all the reasons for the delays, and so it's not necessarily apparent to anyone that this was an unreasonable delay because of the number of years. We need to know the reasons behind them, so we don't have that record.
If I'm sure the reason is knowable, but the authority which should best be able to inform us all has not provided it. So essentially, I would suggest that they're relying on their silence to try and defeat any issue of unreasonableness. But to be that as
I just got to push back on that, because you're asking them to come forward with evidence on an appeal, and they should be confined to the record below.
Well, it would be helpful if we knew about it, but we don't.
But there's a process for knowing it. You're saying if it's knowable, there is a process for knowing it.
I'm sorry, I couldn't quite hear you.
You've indicated that you're certain that it's knowable, and there's a process for you to know it before you come on appeal, right?
Yes. Yes, it could have been known earlier. But I would suggest that whatever the reason was, given the information that we have, it was unreasonable. I should note again that there is no allegation that petitioner is somehow responsible for the delay. We know that the backlog was essentially cleared by 2017. So I would suggest that any procedural delay of 19 months is essentially unreasonable absent extraordinary circumstances. The board cannot, for example, rely on the pandemic to say, well, that we couldn't handle due to reasons outside our control because the pandemic didn't happen until 2020. So if the court does find that the delay was unreasonable or hold so, I should emphasize that the relief that we're seeking is limited, and the courts can allow for limited relief in circumstances. For example, we're not asking, because of the delay, you have to kick them down, you have to reduce them to a level 1, or that the board cannot reclassify them again in the future. Essentially, what we're asking for is to return to the status quo, which is namely a pre-2013 level 2. And there are cases that talk about this, and they're mainly in the SDP line of cases such as Lesage, which was from last year, 488 Mass 175, which said that because of the pandemic and the Commonwealth wanting jury trials, we're authorizing 6-person juries to accommodate that, but also to allow the petitioners to have something within reason due to the pandemic and due to the inability to get large numbers of people close together. And there's another earlier case called Commonwealth versus GF, that's 479 Mass 180 from 2017, which said that that if an SDP has a trial and there is a hung jury and a mistrial, then the court has the authority, even though the statute doesn't allow it, to provide some kind of supervised release while pending the trial. So I would suggest that when delay alone is the issue, that the courts don't always just simply say no prejudice, too bad for you. There are instances, as I pointed out, where the court can allow for a more limited form of relief to be consistent with due process and perhaps encourage the Commonwealth to engage in a more timely fashion. So with that, I would rest on my brief, and I thank you for your time.
Thank you. Ms. Michaud.
Thank you. Good morning, Your Honors. May it please the court, Rachel Michaud for the Sex Offender Registry Board. As you're aware, in the matter before the court, appellant has raised a lone issue, essentially whether SORB reclassified him within a reasonable time period under the statute. I suggest that this court will deem the issue waived. It was not raised before the hearing examiner by hearing counsel, and it was not raised before the Superior Court by different counsel. He had a different counsel for both the hearing and the Superior Court appeal. The courts have long held that issues not raised below are deemed waived. I'll point to an unpublished decision to start, DOE 308290, included in the SORB's addendum at page 53, where a panel of this court that included Justice Massing found that based on applicable case law, which includes the case cited in the board's brief, DOE 3974, that the offender waived the issue of whether SORB violated its statutory and regulatory authority in the same context as the instant matter by not raising it before the agency or Superior Court. This matter is very similar to the instant matter, where the lone issue involved a board reclassification based on new information and the delay in proceedings. The instant matter is unlike DOE 16748, relied upon by DOE to support not waiving the issue, where the offender did not raise an issue before the hearing examiner, but did raise it in Superior Court. There, the issue raised was challenging the validity of the regulations. Here, DOE does not challenge the statute or the regulation's validity, but rather claims that SORB violated its statute or didn't follow the statute in proceeding in a reasonable time period. Here, DOE also, unlike 16748, did not raise the issue in Superior Court. Therefore, I suggest that this court will deem the issue here waived. If this court decides it will consider the merits of the argument despite the waiver, DOE's argument still fails. In DOE 3177, the SJC squarely confronted the issue of new information and reasonableness in timing of the context of board-initiated reclassification proceedings. The SJC ruled that although the board was required to bring a reclassification action within reasonable time, reasonableness is not rigid, but rather requires a fair consideration of the total circumstances of a case. In DOE 3177, the board moved to reclassify that offender in 2015. He was reclassified. The matter was remanded to consider trial transcripts, and there was a procedural issue discovered in 2017, and a new hearing ultimately held in 2018. The SJC found that there the board acted expeditiously when it received informations of allegations of new sex offenses by DOE, and that the delays were reasonable, the delays to finally resolve the reclassification were reasonable and not evidence of any bad faith on the part of the board. The matter before this court is on all fours with DOE 3177, except with an earlier delay caused by the 2015 SJC decision in DOE 38316, where the board's burden of proof was heightened to the clear and convincing evidence standard. Here, DOE was initially classified as a level 2 offender in 2011. In January of 2013, he was convicted of further sex offenses, this time contact offenses against a 9-year-old child. The following month, he was notified that the board was moving to reclassify him based on that information, and the process began. He was reclassified upwards as a level 3 offender in August of 2013. In September of 2015, his 30A appeal was still pending when 38316 came down, requiring a mass remand to rehear those cases under the heightened burden of proof. In July of 2017, DOE was again notified of the reclassification in a preliminary level 3 recommendation. He requested a hearing. At some point after that, and it's unclear in the record, but before a hearing was held, a procedural error was discovered. There is nothing in the record that explains the procedural error or the exact timeline.
Ms. Michaud, yeah, if we, assuming we don't see this Mr. Doe's way, what prevents him from seeking reclassification after our decision? And will he have the ability to raise the argument he's trying to raise for the first time on appeal?
So nothing would stop him from seeking a petitioner-initiated reclassification since it's been 3 years since his hearing in 2019. But I don't believe that he could raise the issue before the board at this point because it would be deemed waived as this classification decision would be affirmed. So I'll be brief, but Doe was on notice of the reclassification proceedings. He was on notice from a month after he was convicted of the subsequent sex offenses. He benefited from the mitigation that he didn't have before by his hearing being held in 2019. He testified on his behalf. He had sex offender treatment records that he didn't have before. He had a support network. And I just want to note that he doesn't challenge the level 3 determination based on substantial evidence here. In sum, the board asks you to affirm its decision, and I'm happy to answer any questions. If not, I will rest on my brief.
I have a question about staleness in the Attorney Stiles cites a couple of cases where the SJC talks about the classification is presumptively stale if it's 3 years after the release. Could you, and those cases confuse me because you're always dealing with past offenses like that. The past offenses are never going to change. So how does the staleness work? Arguments, are those cases distinguishable, or do they have any?
Right. So Doe 7083, for example, I believe that offender was classified over 2 years, if I'm remembering correctly, from his release date. And then based on the regulations, wouldn't be entitled to seek reclassification until 3 years after that. But in that case, the 2 years was considerable because he had just started treatment, I believe. And one of the reasons was by the time he's out, he will have had all this treatment, which would apply as a mitigating factor. That doesn't really apply here because there's no staleness argument where, like I said, he testified on his own behalf at the 2019 hearing. All of the information was up to date at that date.
And he wasn't incarcerated at this point.
He was not incarcerated at this point, no.
Okay. Seeing no further questions, thank you. Thank you both. We'll take this under advisement.
Thank you, Your Honors.
Thank you, Your Honors. Nice to see you, Attorney Stiles. Take care.
Nice to see you too.
That's nice.
Do you guys want to? We should sample after you're done.